Hey guys, this is Vicky. Let's take a little bit of time and we'll go over some legality or some legal issues in nursing. Um, we all should know that, the nurse really is always accountable for the outcomes of his or her actions in caring for patients and when performing our nursing duties. And this does include every aspect of nursing, including assessing, planning for care, providing care, medications, communication, delegation, knowing when to call the provider, critical thinking, obviously patient advocacy, discharge planning, etc., etc., etc. We could go on for a while with all of the different responsibilities that a nurse does accept once he or she does accept a patient assignment. So I do want to take a little time to go through some of the legalities in nursing. This is one of my favorite ladies, Florence Nightingale, but I do like her quote. It may be a strange principle to enunciate as the very first requirement in a hospital that it should do the sick no harm. And we don't ever, for the most part, we don't intend ever to hurt patients or do them harm. But unfortunately, sometimes it does occur, and we need to minimize all of those instances. So I want to take a few minutes and we'll take a look at statutory laws. So laws or statutes. The term law and statute really mean the same thing, but they are laws that are written by legislative bodies, meaning the Congress or state legislatures. These statutes are the most common laws that we see and know. And there are really two types of statutory laws. The first are federal statutes, and the second are state statutes. So let's take a minute and we'll look at just a few of the federal statutes. So these all healthcare facilities that receive funding from Medicare and Medicaid must obey by these rules. And a federal violation can lead to the CMS revoking their funding, which, if you remember back from our economics lecture, this is very significant because most acute care facilities are highly funded by both Medicare and Medicaid. So some of the types of federal statutes include the EMTALA Law, Disabilities Act, Self-Determination Act, and the Health Insurance Portability and Accountability Act. We also know that the Centers for Medicare and Medicaid have the authority to establish new rules and regulations to enhance both patient safety and quality, and also reduce the cost of care. Now, I'm sure that you've heard of this, but CMS has, so Medicare and Medicaid have enacted something called the never events, and these are instances that should never occur in a facility. Some examples include a foreign object retained after surgery, such as maybe maybe not a scalpel, but a gauze, things like that, an air embolism, a blood transfusion error, a stage 3 or 4 pressure ulcer development, trauma resulting from a fall in a healthcare facility, poor blood sugar control, a UTI after a Foley, a surgical site infection, DVT or PE, and a central venous access device infection. If you take a look in your book, there is a list of these, but these are never events that the CMS, it's not a federal statute, but it is something that the CMS watches closely, and for the most part, healthcare agencies are not reimbursed if any of these never events should occur, and that is for the whole entire duration of the stay surrounding that incident. The organization does not get paid. So let's take a minute and we'll take a look at the EMTALA Act, which is the Emergency Medical Treatment and Active Labor Law. So all persons presenting for care must receive the same medical screening examination and be stabilized regardless of their financial status or insurance coverage before discharge or transfer. So what this law really is, it's an anti-dumping law. It's mainly used in the emergency room setting. So it prohibits the I can't even speak today, refusal, there we go, of care for indigent and or uninsured patients that are seeking medical assistance when they're in the emergency department. And it also prohibits the transfer of unstable patients, including women in labor, from one facility to another. Now, we don't typically see this in central Wisconsin, but where there are privately owned organizations and not-for-profit organizations, if one isn't able to pay, right, an organization may see this differently and want to transfer a patient. That would be a violation of EMTALA, and the facility could be fined, and fines can be up to $50,000, and like I said, a revocation of the Medicare and Medicaid funding. So what do we need to do as nurses? We need to advocate for patients and be aware of EMTALA as being violated. EMTALA is primarily for the emergency room. It's not a violation of EMTALA if it is a planned surgery. So let's just say a patient was in a private practice orthopedics office and the orthopedic surgeon said, yeah, you need to have a knee replacement, but the patient was unable to pay. It's not an EMTALA violation if the provider does not do the knee replacement. But it is illegal. Let's say now you're a nurse working in the emergency room and you have a patient who comes in with hypertension and the patient isn't seen or examined and he leaves and he has a stroke. That would be an example of an EMTALA violation. So those working in the emergency room do need to be aware of this law and know that in most emergency rooms it is posted. It is posted in their department. The next law is the Americans with Disability Act of 1990. So the goal of this was to end discrimination against qualified people with disabilities by removing barriers that prevented them from enjoying the same opportunities available to persons without disabilities. So what this means is that a healthcare facility must provide reasonable accommodations to patients and their families. This can be black or white, right? But in many situations it's gray in knowing what the patient may need to be able to be as successful as a person without disabilities. So as for nurses, what we need to do is make sure that we're advocating for patients and be sure that they have a clear understanding of the patient's treatment plan. Make sure that we have informed consent. Promote autonomy in decision making by providing reasonable accommodations, and this could include a voice box amplifier if they're hard of hearing, ensuring that they have batteries in their hearing aids. Maybe it's using a sign language interpreter or making sure that Braille is available, making sure that interpreter services is available, so that everybody has equal care. We then have the Self-Determination Act of 1990, and the goal for this act was to support individuals expressing their preferences about medical treatment and making decisions about end-of-life care. So patients' rights under this act include their participation in their healthcare decisions, right? So making sure that we are advocates for their care and that they are autonomous, making autonomous decisions. Individuals under this act also have the patients do have the ability to accept or refuse medical treatment. And then also is that we have to make sure that they are aware that they have the ability to create an advance directive for health care, potentially a DNR status, living will, or a durable power of attorney. So as nurses, we need again to advocate and educate. Most oftentimes, at least the end-of-life information regarding healthcare advanced directives is really done at admission and making sure do you have an advance directive and do you want information on it, and providing education. If they say yes, I usually make sure that they get the packet of information. I have them read it over, and then I usually will call either pastoral care or social services, somebody to come and help them complete the actual documents. If it isn't too stressful of a time. So I have a few of these kind of mixed throughout here. I want you to take a minute and write down whether you think this is legal or illegal. So you're caring for an elderly female who was rushed to the cath lab for a myocardial infarction. While gone, the patient's daughter, who was an RN, calls, and you update her on her mother's condition. So is that legal or illegal? Well, it's illegal if the patient does not consent to have her daughter, if she doesn't consent to a release of information. However, it is legal if the patient has given consent or there is a written release signed. And a violation, this could be, if release wasn't given, this could be a violation of the Health Insurance Portability and Accountability Act. Okay, so another one. So you're working in the ICU and caring for a patient who is transferred to the intermediate care unit. The next day, you're curious about how he did overnight and if his hemoglobin improved. Thus, you access and review his records. Legal or illegal? Illegal. So this is another violation of the Health Insurance Portability and Accountability Act. So really, once you're not taking care of a patient, you really have no right to looking in their records. Okay, so make sure that when you're done with their care, you should not be going into their records anymore. So another federal statute that we've been referring to is the Health Insurance Portability and Accountability Act of 1996, also known as HIPAA, and its goal was really twofold. One, it was to ensure confidentiality of patients' health information, but the second goal, which is actually Title I, it actually protects health insurance coverage for workers and their families when they change or lose their jobs. We don't really hear too much about that. We hear more about the Title II or the privacy rule, and that really addresses the security and privacy of health data. So what it's saying is that we need to ensure confidentiality of all patient health information by not disclosing patients' medical records to individuals who shouldn't have their eyes on them. Some examples of HIPAA violations that I've seen is, showing colleagues pictures of patients' extremities, legs, wounds, and discussing just for the sake of discussion, and it's really not related to healthcare needs, so it's more like, oh, look at this, isn't this cool? That really could be considered a HIPAA violation. Another one is accessing your own records. Know that it is illegal unless you go to the, well, I don't know if it's so much as illegal, but most healthcare organizations, you do need to go to medical records and sign a release, and then you're able to go and look at your own medical records. But some individuals have been fired at their place of employment for accessing their own records. And then looking at other patients' hospital records when you're not caring for them is a huge violation of HIPAA. Okay, so let's take a look at some state statutes. So the laws, or the state statutes or laws that are determined by each individual state. So there's a few types of state statutes that I've put here. The biggest one is the State Nursing Practice Act and the Board of Nursing Rules and Regs. So each state has its own practice act. The Wisconsin Nurse Practice Act is the statute that defines and controls nursing practice in Wisconsin, and that the Wisconsin Nurse Practice Act are administered and enforced through the State Board of Nursing. So please know that the Nurse Practice Act is a law, and they have the same force and effect as any other law. And so what you really need to be making sure is that you are familiar with the Nurse Practice Act in any state for which you are working. So there is an exercise within this learning plan to get you into the Nurse Practice Act or the Nurse Practice Rules and Regulations. So please take it seriously, and please, you don't have to read through every single statute, but please take a look at it so that you are knowing when you graduate what you're being held responsible for. The other biggest one that I see here is the reporting statutes. Please know that within the reporting statute, it mandates reporting of specific health problems and the suspected or confirmed abuse of vulnerable individuals within society. So reporting in all states include infant and child abuse, dependent elder abuse, and also communicable diseases such as tuberculosis, syphilis. And if you remember back from mental health, there is a link to which diseases are considered communicable diseases. Most of your healthcare facilities, if the patient does become positive, you will be aware. But if you are suspecting infant, child, or elder, or vulnerable, or anybody who's unable to is cognitively impaired, you are a mandated reporter in the state of Wisconsin. On this slide, I just included, this is the Wisconsin Administrative Code, or our rules and regulations through the Board of Nursing. So I just listed the Wisconsin statute is the Chapter 441, which is the Board of Nursing. And then we have chapters N1 through N9. The ones that I would make sure that you at least glance at and look at is N2. And I would specifically, hint, take a look at the requirements within N2 about a graduate nurse. There are specific requirements if you plan on becoming a graduate nurse before you take your NCLEX RN that you do need to follow. I believe that is in Chapter N2, so please take a look at that on your own time. For the exercise, you will be using N7, which is the rules of conduct. And I also believe N6, which is the standards of practice for RN and LPNs. So I would take a look minimally at N2, N6, and N7 because the two you'll use and the N2 would just be a great one to review. When we think about grounds for disciplinary action, we know that the NPA, the Nurse Practice Act, has terminated individual's license for practicing without a valid nursing license. Now, every 2 years, you're going to be having to renew your nursing license. Typically, a postcard comes in the mail. Please do not be the procrastinator and wait until the very last minute to renew your nursing license. You have worked too hard. You took the test. You passed the test. Please don't be the procrastinator who waits until the very last minute. When you get the postcard in the mail, I want you to look at that postcard and say, Vicki told me to pay this right away. You have to pay it whether you pay it today or whether you pay it in a month. You have to pay the money. You have to send it in. You typically have to do a nurse survey. If you practice one day with an invalid license, you could potentially get your nursing license away, and you will definitely be in trouble with the organization for which you're employed. So when the postcard comes, please take it seriously. Please pay the money right away. And just be done with it, okay? Failure to use appropriate nursing judgment, guilty of a felony. I had a fellow colleague who had gotten a OWI and had to go before the State Board of Nursing. So please, I know that we all like to party and have a good time, but you now have to be responsible. I mean, you should have been responsible already. If you're going to be drinking, you need to find somebody to drive for you. You do not want to get your nursing license revoked or put on disciplinary action because of something that you should have known better to do. So you have to make sure that you're thinking ahead. Falsifications of records, failure to complete or incomplete nursing documentation, failure to practice in accordance with the nursing standards, inappropriate behavior or occurrence at work, Medicare fraud, or misappropriation of personal items. Within Blackboard, I put a link, and it is a newsletter that comes out twice yearly. I want you to take a look at it. You can actually go in and you can find any nurse who's been in trouble within that period with the State Board of Nursing, whether that's a nurse practitioner or a registered nurse or an LPN. You are actually able to click on your first and last name is published, and it goes out to all the nurses. And you're actually able to go in and you're able to see what happened, where they are, if the license is suspended, if they're being put on limitations. So take a look at that link and you can go in and check out a couple of them and see how, how significant some of the disciplinary actions, what they've done to put themselves in disciplinary action. So your nursing license is obviously granted by the State Board of Nursing after specific criteria are met. And you can take a look through that. And this is where I strongly, again, advise you to go check out N2 about the temporary permit for being able to use graduate nurse. I do want you to make sure that you protect your license. If your name changes, if you're one that's going to be getting married, make sure that you are changing your name appropriately with the State Board of Nursing. If your address changes, things like that, all need to be communicated to the State Board of Nursing. We already talked about the renewal requirements and obviously knowing your state nursing laws. Now let's talk just a minute about common law. So common law or decisions are made by judges. So nursing practice is also guided by common law, and it's really the body of principles that evolves from our court decisions. From court decisions, that's really what common law is. Common law is continually being adapted and expanded. But two big common law cases that went over was the affirmative duty, so the duty to prevent harm. So making sure that you're always keeping people out of harm, and then obviously patient abandonment. So there's no statutory law regarding patient abandonment. However, this is common law. So it really states that an RN cannot leave a seriously ill patient without ensuring another RN will provide care. So when you're reporting off or when you're going on break, that's why it is so important to make sure that you are giving your team to somebody else so that you could not be found guilty for patient abandonment. Now when we look at civil law can be classified as tort law. So it's a civil wrong or injury that's committed by one person against another person or property. So the person who initially initiates the lawsuit typically will seek damage for the wrongful act or treatment, and then the court system decides the final judgment. So there are really two types of tort laws. One is intentional and one is unintentional. So obviously the unintentional is an unintentional wrong against a person, whereas an intentional tort are those willful acts that violate another person's right or property. So let's take a minute and we'll look at some intentional torts. So an intentional tort, like I said, is the wrong or an intentional wrong or injury committed by a person against another. Within nursing, some of the biggest intentional torts are really assault, battery, defamation of character, invasion of privacy, and intentional infliction of emotional distress. So when we think about an intentional tort, remember that the nurse intends to perform the offensive act, and there are legal ramifications. So the nurse could have fines, restriction or loss of their license, or potentially even jail time. So let's look at assault for an example. So an assault is defined as the threat or attempt to make bodily contact with another person without that person's consent. So assault is causing the person to fear that he or she will be touched without consent, whereas battery is when the assault is carried out. So the unauthorized or actual harmful or offensive touching of a person. So let's just put this in an example. So if it was an assault, so let's say that you're taking care of a patient who hasn't eaten in 5 days. So an assault in this case could be that the RN threatens to put a tube feeding in if the patient doesn't eat enough food or take his or her medications, right? Where the battery would actually be placing the feeding tube. If we were threatening the patient, like, if you don't eat your food, we're putting a tube feeding down, right? And then actually putting the tube feeding down could be considered battery if it was taken, if it was extreme. That's just a minor example. Okay. What our biggest defense to an intentional tort is really informed consent. Informed consent is required in the healthcare environment, and it is the defense to battery. So we have told you about the risks, the benefits, the implications, what it is that's going to happen, and they sign it. And that is saying that, yes, we inform them, and it is our defense to say that they agreed to undergo surgery or agree to whatever it is that's being carried out by the provider. Okay, so legal or illegal, you're working in the emergency department and a young child is brought in by your grandparents with a compound tibia fracture. The child needs to go to surgery. You are unable to reach the parents, thus ask the grandparents to sign the consent for surgery. Legal or illegal? So I would say in this, and these aren't always 100%, but I would say in this case it'd be legal. So if you've tried to reach the parents and they're unavailable, the grandparents may sign the consent. The RN must document the inability to reach the parents. If it is an emergent, life-threatening situation, let's say this child would come in and the tibia would be bleeding out and her hemoglobin would be 3. Really no consent is needed because it is a life-emergent life or death situation. However, if because the grandparents don't specifically have, obviously, parental rights. However, if the nurse did try to call and it's documented, in this situation, would also contact social services just to ensure. But for the most part, it would probably be constituted as legal. So when we think about informed consent, we know that it is, again, our defense against battery, and that all patients should be given the opportunity to grant informed consent before treatment unless there is that life-threatening emergency. So major conditions for informed consent is that it's voluntary, the patient's able to understand what's going to happen, and that it's full disclosure of risks, benefits, costs, and alternatives. Okay. I think that the best way really to ensure that a patient has had informed consent, technically it is the provider's responsibility to get informed consent, and they really should have had them sign the consent. However, most times this does not occur, and it ends up being the nurse's responsibility to get the actual physical signature from the patient before the patient is whisked away to surgery, or maybe before the patient gets blood. I feel like the best way to ensure that the patient has been told about the risk, benefits, things like that, is to ask the patient. Did the provider talk to you about it? Can you tell me about some of the risks and benefits to undergoing surgery? You also can look in the physician's or provider's history and physical or progress notes, potentially talk to the provider, or hopefully witness the discussion to know that it had occurred. However, if you're uncertain, still at the end of that, it is still the responsibility of the nurse to contact the provider and say, you need to come and speak to the patient about the procedure you're planning on doing so that I can have them sign the informed consent. What I find most providers lacking on is when you have to give blood, and that nobody has truly talked to them about the administration of blood products. Surgeries they're usually pretty good at, but blood, on the other hand, is one area where I've had to call providers a few times to say, hey, nobody's talked to this person about it, and it's not the nurse's responsibility to disclose that information to the patient. All right, another intentional tort is the defamation of character, which means that it's, in general, it's a person's right to be free from attacks on his or her reputation. So when we have an attack that's written, it's called libel, and when it's spoken, it's considered slander. So libel is an injury to one's reputation caused by written words. So some examples I often think of, at least when I worked in the emergency room, is labeling writing in a patient's chart that they're a drug seeker. You have to think about if somebody else read that, or if the patient reread that himself, could that patient consider that a defamation of character? And for sure, it could. The other thing I want you to be careful with, and I see that we write it a lot in nursing school, is that the patient complains. Like if they're having pain, patient complains of having back pain, 8 out of 10. Well, I strongly encourage you to, when I think of the word complains, I think of it as negative, like, well, she's complaining, and so I have to do something about it. Usually when I chart, or when I used to chart, I would put that patient states. It really takes that negative viewpoint out of it, because that's really what they're doing to me. They're stating that they're having pain out of 8 out of 10. When I say they're complaining, that's just me assuming that they're complaining. But maybe they're just telling me that their pain is out of 8 out of 10. So I strongly encourage you to stop using complains and use states instead. Now, slander, on the other hand, is an injury to one's reputation by spoken word. So slander is often overheard by families when the RNs are speaking to each other, potentially outside of the rooms. It's amazing how much you can hear when you're inside of a room and it's quiet and the nurses are speaking outside, so you need to be really careful. Oftentimes the nurses can damage a patient's reputation speaking out loud, maybe by telling another nurse that the patient's lazy or that they're non-compliant. So I just advise you to be careful when speaking about a patient and use only objective and professional language. Then we know for sure that slander is not occurring. Okay, so you're working in the ER and caring for a patient who is admitted due to severe intoxication. During your assessment, the patient becomes belligerent, agitated, and shows violent behavior, so you apply hand restraints and closely monitor. Legal or illegal? In this situation, if a patient is harmful to others or to themselves, restraints are acceptable practice, but a physician's order is required. Okay, and very close monitoring. Usually organizations will have policies regarding it. Okay, the next one. So you're working on the medical floor and caring for a patient with sundowners. To prevent the patient from getting out of bed, you raise all 4 rails. Legal or illegal? In this case, it would actually be considered illegal. Having all 4 side rails up is considered a type of restraint and could be considered false imprisonment. So when we think of the next intentional tort, false imprisonment, so it's obviously the unlawful restraint or detention of another person against his or her wishes. So patients have the right, if you remember back, patients have the right to self-determine and can refuse care if they're mentally competent and do not face a danger to others. So patients may leave against medical advice, but they do need to be aware of the risks in doing so, and the physician and or supervisor must be aware. If a patient is leaving AMA, they do need to sign documents, and on those documents it does need to list the risks of leaving, and most oftentimes death will be one of those risks because you're not sure. Examples of when restraints really are not okay is if you don't stay in bed, I'll have to sedate you. Maybe you restrain a patient who's continually pulling out a tube feeding. So, are there ever circumstances when false imprisonment is acceptable? I think we kind of touched on this a little bit, but there are times when a patient must be restrained. So if they're harm to themselves, maybe due to confusion or sedation. So an example I often think of is if you're working in the ICU, patients will be restrained. Maybe because so they don't pull out their ET tube, but there are strict guidelines that must be followed, or if there are harm to others, so maybe the intoxicated patient in the emergency room or the very agitated person in the mental health setting, they may potentially need to be restrained. But remember that the goal of restraints is to use the least restrictive restraint, and only when all other strategies have been used and have been exhausted. Okay? So if we think about what are some other strategies that could be implemented, for sure could a patient sitter be involved, distraction, maybe ambulation, maybe modify the role, the model of care, the RN model of care. Some types of restraints can include seclusion, chemical restraints. Physical restraints could include vests, mittens, belts, wrist restraints, the bed rails times 3 and 4, and then chair tables which entrap a patient in a chair could be considered a restraint. If restraints are used, an MD assessment and order is required. Close monitoring by the nurse is required, so please take a look at the agency policy. Obviously documenting, and documenting, because it's very important that you have the information documented appropriately and in a timely fashion. And then obviously stopping the restraints when the patient meets the appropriate criteria. I love the little picture. Cracks me up. Okay, legal or illegal. You're caring for a patient with a new diagnosis of cancer. To better help the patient understand, you draw pictures and write the diagnosis on the patient's message board within the room. The patient is then taken to have a chest x-ray. Is that legal or illegal? So this could be twofold, right? It's legal if the message is removed prior to the patient leaving, or if the patient says, yes, it's okay that the picture stays up there. However, it is illegal if one, the patient says, if the drawing isn't removed, or the patient says that it's not okay that it's up there. Because if you think about this, let's say that the patient was just diagnosed with cancer and he hasn't told his daughter or his wife yet, and now the daughter and the wife come into the room while he's gone for chest x-ray. We've just violated HIPAA on this patient because we've told information to the family members inadvertently without the patient wanting them to know. So when we think about invasion of privacy, I think that we've already talked about this enough, but it's really about confidentiality. So you can take a look at this intentional tort. Okay, so when we think about unintentional tort, so an unintentional tort, remember, is a wrong or injury committed by a person against another unintentionally. So when we think about an unintentional tort, the one that I think of first is negligence. So it's the failure to act in a reasonable and prudent manner, and testimony is not required if it's taken to court. So let me give you an example of an easy example of negligence. So I live in the country. So if I live in the country and I have the option of having a garbage service or not, and I'm really not, I have garbage service, but I'm just using this as an example. If I'm too cheap and I decide, no, I'm going to burn my garbage. Well, I decide to burn my garbage on the windiest day in Marathon County. And halfway through burning the garbage, a spark goes into the woods and burns down 40 acres of woods. That could be considered an unintentional tort or an example of negligence, and which anybody would know that burning garbage on the windiest day in Marathon County is not a very good idea. Okay? So that would be a simple case of negligence where testimony is not required if it was taken to court, because the average person would know that that's not a reasonable or prudent thing to have done. Now, when we think of types of negligence, we can think of gross versus criminal negligence. So when we think about in the nursing world, gross negligence, so the nurse is so reckless and reflects a conscious disregard for the patient's welfare. So the patients often don't die, but they can suffer because of the nurse's actions. Okay? So if we think about this as an example, maybe a patient up on the CTU gets a pacemaker, and the nurse chooses to not assess the site or change the dressing for 3 days, and we send the patient home, and we never noticed that it was getting red and infected, and now the patient comes back 2 days after being discharged and has to have the pacemaker removed and be put on antibiotics forever. This could be considered gross negligence. The nurse was reckless and didn't do proper dressing changes or site observance. Now, criminal negligence, on the other hand, is where the nurse is deemed so reckless that the action results in serious harm or death to a patient. So they could lose their job or definitely be in reprimand through the State Board of Nursing. An example I think of is there was a patient years ago that I think some of you may have heard this story, but they had TPN running, and the TPN was supposed to be at 100.4 or something wonky like that, and the nurse inadvertently put it at 1,004, and the patient ended up dying. So that could be an example of criminal negligence. Okay. All right, so let's take a look at the research on negligence. For the most part, we know that most negligent claims are done in acute care setting, approximately 61% of them, followed by long-term care settings at 18%, and then it kind of decreases from there. So if you're going to be working in an acute care facility, I'm not saying that you're going to have a claim against you. My hope is that you're not, but, it's a very fast-paced environment where accidents inadvertently do happen. Now, malpractice, on the other hand, is still an unintentional tort, but it's the failure of a professional, so a person with specialized education and training to act in a reasonable and prudent manner. And if malpractice is taken to court, an expert witness would be required. So let me give you an example. Let's say I'm taking care of a patient on CTU, and they're diagnosed with acute heart failure, acute systolic heart failure, ejection fraction of 10%. So the resident comes by and writes an order for 200 milligrams of lisinopril. Okay, well, an experienced nurse knows that the dose really should be 20 milligrams of lisinopril. But when a new nurse is reviewing the orders written, she doesn't really question it. She never addresses it with the physician. There's a new pharmacist on board, and the pharmacist puts the medication in as lisinopril 200 milligrams. The nurse gives the lisinopril 200 milligrams, and the patient maybe suffers from extreme hypotension and dies. I know this is kind of extreme, but this could be considered a case of malpractice because the RN in her training should have known that this was too high of a dose of lisinopril. So an expert witness would need to be called because an average person would not know, an average non-healthcare person would not know that 200 milligrams of lisinopril would be too high. However, in this case, in most malpractice suits, anybody that's involved could be taken to court. So the nurse, the pharmacist, and the physician could face possible malpractice suit because all should have been aware. Unfortunately, as nurses, we're always the end result. We're the ones that have to give the end result. Or the stopgap. We have to be able to recognize and correct and clarify at any time. Some other contributing factors in malpractice suits is obviously downsizing, so having to work harder with less, advances in technology, autonomy and responsibility, informed consumers, and early discharge. Remember, if we go back to DRGs, right, they're getting paid on how many, whatever the DRG is assigned to that patient. So if they can get them out earlier, the hospital would make more money. So we have to be advocates to ensure that the patient is being treated appropriately and in a timely fashion and being discharged appropriately when they're ready. So legal or illegal, you're working a 3 to 11 and you're assigned to a patient who sustained a tibia fracture with a cast in place. During rounds, the patient states his leg is hurting more than normal. Upon assessment, the net leg is edematous with skin color changes. You notify the MD, but he or she gives you no orders and states that he or she will be in to see the patient in the morning. So it's 3 to 11. Legal or illegal. This really would be considered, it's not really legal or illegal, but I'm just terming it as that, but it would be illegal. So it's the failure to adhere to standards of care. The MD is responsible, but as the RN, would be your responsibility then to seek further help when you know something is not right. And it's not uncommon where you may have to go above and get the hospital supervisor involved, have the resident doctor come up, maybe even go down to the ED if you're not getting where you need to with the patient's primary care provider or specialty provider. Okay, so your patient is scheduled to have a coronary artery bypass graft in the morning. In preparation, you have the son translate questions and answers and the explanation of the informed consent. The son translate that the patient understands, and then you have the patient sign the consent to surgery. Legal or illegal? So this would be considered illegal. There is no way that you can confirm what the son said, what the son translated, and that the patient understood and had no questions. In this case, an interpreter would need to be present, and through the interpreter, then the patient we would be able to confirm that the information was correct and that the patient did not have any questions and that it was safe for them to sign the informed consent. So this is just a list of contributing factors to malpractice. Please take a look at it. I'm not going to read through all of them. Legal or illegal, a fellow RN asks you to co-sign the MAR, so the medication administration record, for a heparin drip. After co-signing, you go and look at the IV infusion rate to confirm accuracy. Legal or illegal? This would be illegal in its failure to follow standards. Many high-risk medications are a dual sign-off, meaning that two nurses have to confirm that, yes, the medication is running at the correct rate. So heparin, some facilities have insulin drips, PCAs, this can be facility driven. However, in this case, it would have been legal if the nurse would have asked me to co-sign the drip. I would have went in there and said, yes, the drip is, I look at the drip, I know it's heparin running, I know that I've got 1,000 units per hour, I know that that's what my MAR says it should be at, I looked at the patient's PTT, and I know that that's the right rate, and I know, I'm confirmed, everything is good, and then I sign off the order. I cannot tell you how many times I see nurses just co-signing MARs, and they haven't actually went in and looked at the patient's medication, IV, whatever it is. Please know that when you co-sign something, it is just like you are the patient's nurse in that co-signature. So please take it seriously, along with giving blood. Take that very seriously. So you're working on the medical floor with a CNA who's a 4th-semester nursing student. The student wants to gain experience placing IV catheters, so you allow the CNA to place the IV. Legal or illegal? In this case, it would be illegal in its failure to provide care within the standard of the RN care. It increases the risk for the patient. You have to remember that the CNA is not in that moment in the role of a student. The CNA is in the role of the CNA. And it's very important not to get those confused, because if something would happen, you and the CNA may not be covered within the hospital's policies and procedures. More contributing factors, please take a look through these. I'm not going to read through them. It's 10 a.m. and you're documenting your 8 o'clock assessment. While documenting, you don't change the time back to the original assessment time. Legal or illegal? So again, this would be illegal, and it's the failure to document accurately. So remember that the morning assessments do need to be timed to when the morning assessment was actually completed. It's not uncommon for you to have to go back to change the charting, or to document the charting, because you're not charting. You should be charting in the moment. However, if you don't, you need to make sure that you're charting the correct time. Please read through the failure to document. Legal or illegal, the CNA tells you that your patient's blood sugar is 46. You direct the CNA to give the patient orange juice while you go to the next patient. Legal or illegal? Now I know some of you want to say legal, however this would be illegal. First off, it's the failure to assess or reassess the patient, and it's also failure to properly delegate. There is no way that you know if the patient's blood sugar, is the patient even conscious with a blood sugar of 45? Remember, anything under 60 is abnormal, and some people even at 55 are very symptomatic. So it is illegal for you to not go and assess the patient prior to having the patient get orange juice. If they would be partially unconscious and you told the CNA to go give orange juice and the patient aspirated, you will then be legally responsible for what occurred. Please take a look at these. I just enjoy this cartoon so much. My goodness, when's the last time anyone checked on Mr. Clink? Funny. All right, I think this might be the last. Oh, no, we got 1, 2, Two more. Okay, so it's 10 in the morning and you're following up on a recent MD order regarding your admission of a patient diagnosed with a pulmonary embolism. You note that pharmacy scheduled the fragment to start at 4 p.m., so you change the time for the fragment to start at 11. Legal or illegal? So it's 10 o'clock, 10 o'clock, patient's got a PE. Pharmacy, for some reason, didn't start the fragment until 4. You want to change it to give it the first dose now. Now, the first thing as a new nurse, I would check with the pharmacy to ensure, ask them why they scheduled the dose out to 4 p.m. That would be my first recommendation for a new nurse. But it is okay for you to change if they had no reason, and if you didn't give the fragment, the patient has a known PE. That's 6 hours, 10, 11, 12, 1, 2, 3, 4. That would be 6 hours later. That could be considered a failure to implement a plan of care, especially if the physician did an order for the first dose to be at fragment or at 4 p.m. So what I would highly recommend is if you notice things like this, to call the pharmacy and ask them, because remember that many times pharmacy just picks times to start medication, and if we needed the patient to be on a type of blood thinner for the PE and we delayed it by 6 hours, we're really putting the patient at higher risk if we don't implement it, if there's not a good reason why the fragment wasn't started sooner. Okay, so the last thing I want to talk about is the nursing malpractice. Is the client, in order to prove that malpractice is legitimately a case, the client or family must prove the 4 following things: that the nurse owed the client a duty of care. Well, as soon as you accept the patient as your team, you now owe the client duty of care. Okay. The second thing that they must prove is that the RN breached this duty, meaning that the evidence is present that proves the RN breached the standard of care. The third thing is that actual harm or damage is suffered by the client. And then the fourth thing is that there is a connection between the breach in the standard of care and the client's injury. So all 4 of those do need to be present for a malpractice suit to be considered viable. Okay, so legal or illegal, you're driving into work and come upon an accident in which one of the patients was ejected. After assessing the situation, you determine the patient is not breathing, so you begin CPR. This is actually legal. The Good Samaritan law states that you can provide care that is consistent with your expertise, but not anymore. Okay, and then our last one. You are grocery shopping and witness a man collapse to the floor. You rush over and find that he is alert but slightly confused and sweaty. The wife states that he has a history of diabetes, seizures, and has had an MI. He also states that he gets like this when his blood sugar is low. You call 911 to get the patient. You call 911 and get the patient some orange juice. The patient seems to improve. The ambulance is on its way. Thus, you decide it's okay to leave the patient. So actually, everything up until the point of leaving the patient was legal. So within the Good Samaritan Act, once you start taking care of a patient, it is required that you stay with the patient until you are able to hand care off to another healthcare provider. Failure to do so could actually mean patient abandonment. So please, if you decide to act in the public, please know that you do need to stay with the patient until another person is able to take over for you. So what more specifically the Good Samaritan law says is that it grants immunity from liability to healthcare providers when providing emergency care outside of a healthcare agency. The healthcare worker is required to render the same level of care that is reasonable with the resources that are available. Okay, so let's just give you an example. If a patient falls off a ladder, any nurse would know that they need to stabilize the spine and let the patient stay there and support the spine to ensure that they don't have any fractures or have any spinal cord injury. Okay. Now on the other hand, let's say you have a patient who's choking, just like in that picture. You do the Heimlich maneuver. You're not able to get it out, so you do a oh God, I can't think of, like the tracheotomy with the pen thing, that you see. Obviously, we're not trained to do that. That would be illegal. You may not be protected under the Good Samaritan law. So please do what you're trained to with the resources that are available within the community, and stay with the patient until you're able to hand that care off to other people. Some questions that I want you to consider, okay? And then lastly, nursing standards of care. So these are just ways that you do need to stay current with the standards of care through evidence-based practice. So organization policies and procedures. Most organizations will have nurse educators. Obviously, going to educational seminars, which are always fun. Conferences, nursing journals, annual skills fairs are great ways to stay competent within your nursing knowledge and interventions. Other ways to reduce your risk. And then lastly, liability. And I put on here why insurance. I think that it is important for you to have malpractice insurance. And if you want, please take a look at this video. And I believe there's also stuff within Blackboard. So if you have any questions about the legal lecture, please let me know.